Welcome to Topics of Discussion. I'm your host, Ron Jones. If you've been following the true crime or local news landscape over the past few weeks, you already know the basic. Shocking framework of what happened on April 21st, 2026 at the Centerville Mills Dog Park on Crackle Road in Bainbridge Township, Ohio. You know about the verbal argument over Donald Trump. You know an 80-year-old grandfather, Emmanuel Mike Mathews, pulled the trigger. And you know a 55-year-old Marine Corps veteran, David Mathews, was hospitalized with severe injuries. But today, we aren't here to rehash the basic timeline of that bloody Tuesday afternoon. Today, we are opening up the legal playbook. On June 10, 2026, Emmanuel Mathews stood inside a Geauga County courtroom and officially entered a plea of not guilty to the second-degree felonious assault. The case is no longer just a shocking piece of a suburban gossip. It is now a high-stakes, highly technical chess match heading straight for a 12-person jury trial. Over the next few minutes here, we are breaking down the exact legal standpoints of both the prosecution and the defense. We will look at how Ohio's updated stand your ground laws changed the math for both sides. We will examine the fiery arguments over Mathews' bond conditions, and ultimately we will analyze why this case completely redefined the boundaries of the self-defense, age, and political escalation in America. Grab your seat. Let's dive into this legal reality of the Bainbridge Park shooting. Let's start with exactly what the state is throwing at Emmanuel Mathews. A Geauga County grand jury returned a single count indictment for felonious assault. Under the Ohio Revised Code, this is a second-degree felony. Now, on paper, a second-degree felony carries a potential of 2 to 8 years in prison, alongside a fine of up to $15,000. If you're an 80-year-old man, 2 to 8 years in prison is already a massive and potentially terminal chunk of time, but the state didn't stop there. Special Prosecutor Seth Enlow tacked on what's called a firearm specification. In the state of Ohio, if you use a gun to commit a felony, a firearm specification adds a mandatory, flat, 3-year prison term to your sentence. The crucial legal word here is mandatory. And the second crucial word here is consecutive. This 3-year penalty cannot run at the same time as the assault sentence. It cannot be negotiated down by a judge at sentencing. It is stacked directly on top. Let's do the math. If a jury finds Mathews guilty, the absolute legal minimum sentence Judge Carolyn Paschke could give him is 5 years. The maximum? 11 years. For an octogenarian in failing health. The math is brutal. A conviction at trial is, for all intents and purposes, a life sentence. This is why the stakes in Geauga County Court of Common Pleas are incredibly high. There is no middle ground here for the defense. They aren't looking to minimize a sentence. They are fighting for an absolute acquittal. But to get the acquittal, prominent Cleveland defense attorney Ian Friedman has to navigate a mountain of physical evidence. Let's look at what the prosecution is planning to put in front of those 12 jurors, should it go to trial. When Special Prosecutor Seth Enlow stands up front above the jury, his narrative will focus on one core legal principle: proportionality and retreat. The prosecution's standpoint is that Emmanuel Mathews introduced deadly force to a situation that did not warrant it. Yes, there was a heated political argument. Yes, feelings were hurt and voices were raised. But the prosecution intends to prove that David Mathews did not pose an imminent threat of death or great bodily harm at the exact moment Mathews drew his weapon and fired. And the state believes they have the smoking gun to prove it, quite literally. During the court proceedings, Enlow dropped a detail that completely anchors the state's case. He looked at the court and stated, and I quote, "Most importantly, Mr. Mathews shot the victim in the back." Let's pause and think about the legal weight of that sentence. In any self-defense case, the physical mechanics of the wound tell the story. If a defendant claims they fired because someone was charging at them, lunging at them, or threatening to kill them, you would expect a front entry wound. A bullet entering a victim's back or hip area strongly signals to a jury that the victim was either walking away, turning away, or, as Mathews' wife claims, simply trying to put his dog back into his vehicle. The prosecution will argue that Mathews was disengaged from the physical confrontation, or at least attempting to leave when Mathews fired. But what about the chaotic detail we heard from the preliminary hearings? The fact that David Mathews reached into his own car after being shot, pulled out his own firearm, and shot at Mathews' retreating vehicle. From a legal standpoint, the prosecution is treating Mathews' gunfire not as an act of aggression, but as a justified reactive measure of survival. If someone has just shot you in the lower back and you are carrying a legal firearm, returning fire at an escaping vehicle can legally be framed as a defense against a continuing volatile threat. The state is building a box around Mathews. They're painting him as an angry older man who got offended during a political debate, lost his temper in a parking lot, used a firearm disproportionately against an unarmed man, and then fled the scene. But if you think this is an open and shut case for the state, think again, because the defense has a wildly different, highly aggressive strategy. If you know anything about the defense attorney Ian Friedman, you know he doesn't just walk into a courtroom just to play defense. He goes on the attack. And his legal standpoints for Emmanuel Mathews are designed to completely flip the script on who was the actual real victim in this case. Friedman's entire defense turns on a crucial piece of testimony that came out during the preliminary hearing from the Bainbridge Police, Brian Kaufman. Under cross-examination by Friedman, Officer Kaufman admitted something massive under oath. He testified that during the initial altercation at the dog park fence, David Mathews physically assaulted Emmanuel Mathews. Specifically, Special Prosecutor Seth Enlow later acknowledged in this court, admitting that there was evidence early in the encounter that the victim grabbed Mathews and maybe grabbed his hair. Now let's look at this through the eyes of the defense attorney. Friedman is going to look at those 12 jurors and say, "The prosecution wants you to think this started when my client pulled a gun. No. This started when a 55-year-old, physically imposing Marine veteran laid his hands on a frail 80-year-old man and violently pulled his hair over a political disagreement. By establishing that Mathews was the initial physical aggressor, the defense drastically changes how the jury evaluates Mathews' fear. Under Ohio law, you don't have to wait until you are actively being beaten to defend yourself. You have to possess a reasonable fear of imminent danger." Friedman will argue that the 80-year-old man, having just been physically assaulted and grabbed by the hair by a much younger veteran, was in a state of sheer terror. Furthermore, the defense highlights what happened next. According to police testimony, Mathews left the immediate area of the fence, but returned to his car just minutes later. When Mathews noticed that Mathews had a firearm on him, Mathey allegedly made a pointed, threatening remark. "Oh, you've got one, I've got one too." Friedman's standpoint is that when Mathey went to his vehicle after making that statement, Mathews had every reason to believe Mathey was retrieving a weapon to finish the physical assault he started at the fence. Mathews didn't shoot a man putting his dog away. He shot at a man who had already assaulted him and was actively reaching for a weapon. And Friedman took it a step further during the June 10th arraignment. He told the court that he fully expects David Mathey to be criminally charged himself for his role in starting the fight and assaulting Mathews. This is a classic defense theater, but it's backed by legal strategy. If the defense can convince the jury that Mathey was a criminal aggressor, Mathews' decision to shoot became a legally protected act of self-defense. But as we look at this battle brewing between the defense and the prosecution, we have to look back at every inception of this case to find one of its biggest open questions. Very early on, the Geauga County Prosecutor's Office did something highly deliberate. They submitted a formal notice stating that there was a conflict, and they petitioned the court to step aside so an outside special prosecutor, Seth Enlow, could take over the case. This leaves us with some gnarling question that the public deserves answers to. Why would a county prosecutor's office voluntarily hand over a high-profile case like this? What constitutes a legal conflict in a suburban dog park shooting? In criminal law, a prosecutor's office will declare a conflict for a few major reasons, and they usually boil down to relationships. First, did either Emmanuel Mathews or David Mathey have a personal or professional connection with the Geauga County's prosecutor's staff? Is one of them related to an employee? Do they share a business relationship? If a prosecutor tries a case involving a friend or an associate, the entire trial can be tainted by the appearance of bias. Second, think about the political lightning rod at the center of this event. This entire fight started as a debate over Donald Trump. Is it possible that the local prosecutor's office recognized that the hyper-partisan nature of this case could make any decision they made look politically motivated? By stepping aside and bringing an independent special prosecutor from an outside the county system, they ensure that the prosecution is insulated from the local political pressure. By doing this, they left us with an enduring mystery. Because the exact nature of the conflict hasn't been blasted across the front pages, it leaves a lingering question in the background of the trial. Who in that local system is connected to this incident? And did that connection impact how the initial investigation was handled? It's a piece of the puzzle we will be watching closely as discovery moves forward. To truly understand how this trial will play out, we have to look at how Ohio's legal landscape has shifted over the past few years. Historically, in Ohio, if you were outside your home, your vehicle, you had a duty to retreat. That meant if someone threatened you at a dog park, you had a legal obligation to try to run away, get in your car, or walk away before you could ever justify using deadly force. But Ohio changed that. Under the current Stand Your Ground framework, a person who is lawfully in a public space, like the Centerville Mills Dog Park, has no duty to retreat before using force in a self-defense as long as they aren't the ones who started the criminal activity. Key point. This completely alters the prosecution's burden of proof. In the past, the defense had to prove that they acted in self-defense. Today, under Ohio law, once the defense puts forward even a tiny bit of evidence suggesting self-defense, like the fact that Mathews grabbed Mathews' hair, the legal burden shifts completely to the state. Now, Special Prosecutor Seth Enlow doesn't just have to prove Mathews fired the gun. He has to prove beyond a reasonable doubt that Mathews did not act in self-defense. The state has to disprove self-defense. Enlow will try to do this by showing that the threat had ended. The shooting in the back was an act of retaliation, not protection. Friedman will continue by saying that the threat was active, involving, and terrifying to an elderly man. It is going to be a brutal battle of definitions. While we wait for a formal trial date to be set by the Geauga County Court of Common Pleas, Emmanuel Mathews is experiencing a very specific type of legal limbo. During that June 10th hearing, there was a massive tug-of-war over his freedom. Friedman argued that keeping an 80-year-old man in poor health under strict house arrest was unnecessary punishment before he's even been convicted. The prosecution fought back hard, stating that the public safety and the risk of non-appearance on the case that carries mandatory prison time required strict boundaries. Judge Rambo ultimately split the difference. He officially lifted Mathews' house arrest requirement, giving him the freedom to attend doctor's appointments and handle his medical needs. However, the electronic leash still stays on. Mathews must still wear a GPS ankle monitor at all times. He faces a strict no-contact order regarding David Mathews, and perhaps most symbolically, he is completely banned from ever stepping foot back in the side of Centerville Mills Dog Park. A quiet community park, a heated political debate, physical altercation, two men pulling firearms. The legal standpoints are drawn in the sand. 12 ordinary citizens of Geauga County will soon have to decide where that line between a terrified reaction and criminal assault truly lies. This is all the time I have for today's deep dive on topics of discussion. I'm your host, Ron Jones, and thank you for listening.